Dear all, a very good morning to all of you. Myself, CS Khushbu Mohanty, Assistant Director at ICSI. I welcome you all to
Recording
the
has started.
Triple E 2.0 webinar series. Friends, we have today the session on SEBI Prohibition of Insider Trading Regulation 2015. Before I proceed to introduce our eminent speaker, I would just like to say a few lines about the SEBI PIT regulations. As you all know, the companies are rushing towards holding board meetings and preparing for the AGM, where many important decisions relating to financials, material price sensitive information will be taken. So it is very apt time to keep this theme as SEBI PIT regulations, as it may that decisions taken at the board meetings may relate to and fall under the purview of provision of insider trading. And again, the one thing I would like to share with you all that the SEBI PIT regulation is one of the toughest and stringent regulations at par with the international best practices. So whether our professionals who are new to the profession or they are working in the listed entities or working with some other entities like merchant banker intermediaries, they all fall under this purview of this insider trading. So today we have our own Madam Salashri Bhaskar, who will give you a detailed analysis and a deep insight into the SEBI PIT regulations. But before I hand over the session to ma'am, I would just like to give a brief introduction of Madam Salashri Bhaskar. So Mrs. Bhaskar is a commerce graduate, an MBA from the Madurai Kamraj University, Madurai, and a fellow member of the Institute of Company Secretaries of India. She has been in the practice for the last 18 years with specialization in SEBI related areas and also handle compliance, corporate governance issues, secretarial audits. She was with SEBI for nearly 10 years and resigned as a Deputy General Manager before starting practice. She is a regular faculty at various programs and seminars organized by the ICSI, Institute of Chartered Accountants of India, NISM, NSC and the BSc. She has spoken on a variety of topics including SEBI takeover codes, SEBI ICDR regulations, SEBI insider trading regulations, preferential allotment of securities, SEBI listing regulations and SEBI settlement regulations. She is one of the specialist editors to the last edition of Ramayya's Guide to the Companies Act and also to the latest edition of the MC Bandari's Guide to Company Law Procedures. She is a co-author of books on the SEBI LODR Regulation 2015, SEBI ICDR Regulations 2018, SEBI SESH Regulations 2011 and SEBI PIT Regulations 2015, SEBI Buyback of Shares and SEBI Delisting of Shares Regulations. Madam, we welcome you to this wonderful session and I hope this will be a learning to all the participants. So I'm handing over the session to ma'am. Over to you, ma'am.
Thank you so much, Khushbu. And good morning to all of you. And I hope you all enjoy the session as much I look forward to enjoying it as well. And so first, before we start, let's share my screen and we'll go forward from there. Now, insider trading is an area which has fascinated everybody. Whether it is authors, whether it's been movie makers, everybody has been fascinated by this theme. And we have seen a lot of books written about it, movies that have been made about it, both in Hollywood and even in our own very own Bollywood. And it has kept regulators awake for a long time because they've always been wondering whether any rally in the stock market is fueled by an act of insider trading or is it a simple rally or so. And not only has it kept all the regulators awake, it has kept us professionals very busy too, because we have always been wondering whether a particular information that is floating in the organization is attracting the provisions of the PIT regulations, whether it requires any disclosure, whether it requires any corrective action to be taken, whether any of our own designated persons have done something which attracts the provisions of the regulations or not. So therefore, is the screen. Yeah. I thought I should give the introduction and then press this. Can you see it? Can you see it?
No, ma'am.
Can you see it now? It's open?
No.
I'll share again.
Ma'am, please maximize your presentation because I think due to minimization it is not showing us properly.
Yeah.
So please maximize. And now it's visible, ma'am.
Okay. Yeah. Now is it moving also?
Not moving, but it is visible.
Yeah, it's full screen. Now? Now? This one? Is it moving? Yeah? Okay. Yeah. Yes. So, as I was telling you, so insider trading is a topic that fascinates everybody and keeps not only the regulators but as professionals and everybody awake and wondering whether we are complying with the regulations or we are missing out something at some point in time. So, therefore, there is an urgent need and an immediate need for this session, and all of us should be aware what are the regulations, how is it to be interpreted, what we should comply with, what are the do's, what are the don'ts. So, some of the questions that always keep popping up before us when we handle any unpublished price-sensitive information is whether this should be kept confidential, can we share it with somebody, or should I share it with some caveats, how am I supposed to handle it? And even after having shared this information, have I done it correctly? Have I shared it with the people who are supposed to have it? Or have I shared it with somebody who's not supposed to have it? Or can I trade? Are we supposed to close the window? And even when we are trading, whether the trade has been done correctly, whether there are any disclosures, and in case something has gone wrong, how to protect myself, how to protect the company. All these are questions that will keep popping up every time. And so therefore, first and foremost, without any this thing, let us look at what the regulations say, or what is the scenario in India with regard to the PIT regulation. Now, Kushbu, while she was introducing, she said that it's AGM season, board meetings must be happening, and she was also saying that Indian PIT regulations ranks one of the best in the world. It compares itself, it aligns itself with the regulations in the in other developed countries of the world, which is very, very true. So while we are moving towards the AGM, definitely there will be so many resolutions that will be passed, which will get the approval of the shareholders. But before we actually go to the shareholders, it's the board meetings which actually take more prominence and more importance, because most of the decisions in the company are taken at the board meetings, and information will have to remain very confidential till such time they are discussed and debated and decided upon at the board meeting, because post board meeting we always disclose it to the stock exchange. And in India, until the year 1992, SEBI got a statutory recognition in the year 1992. Till such time, insider trading was not talked about much. Probably there were activities which were equivalent to insider trading, but then we were a very closed market. We were not integrated with the other markets of the world. And so therefore, there was not much of need or much of debate or discussion on this. But as soon as SEBI got a statutory recognition, in fact, one of the first regulations that was notified by SEBI was the insider trading regulations. At that time, all these were called as guidelines, and then later on, over a period of time, guidelines transformed into regulations, because regulations have more power to be implemented compared to a guideline, because guideline is after all only a guideline, whereas regulation comes with the power to enforce, to take necessary action, etc. And from 1992 onwards until 2015, the regulations did not undergo much of a change. And if you see, there were not many cases also which were decided upon by SEBI. In fact, they were always accused as somebody who was taking action post an event that has taken place. Many people, even in the newspapers, amongst others, would discuss and debate that it was reactive action rather than proactive action. But in 2015, there was a committee that was formed under Justice Sodhi, who went in detail into the various informal guidances that had been given, the various judgments that have come about from SAT, from Supreme Court, and various other authorities. They looked into the insider trading regulations in the various parts of the world, and thereafter, the regulations have been notified. And if you see in the last 5 to 6 years, the number of orders that have been passed by SEBI, so many have been passed, and they have proved without any doubt that there has been an act of insider trading that has actually taken place. And how has all this happened? Because SEBI's wherewithal to access voice records, to get or confiscate mobile phones which are used for transferring of this information, various software that has been installed within their system, their 24/7 surveillance mechanisms, all this has enabled the regulator to pick up any suspicious trading that takes place, collect the information, and also the speed with which the decision is coming has also been very, 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 amazing. And that has helped us to understand now that insider trading is something that is going to be dealt with very, very seriously by the regulator. And some of the big orders you might have seen in the recent past is of Amlendra Mukherjee. Yeah, I am using headphone. Yeah, I'm using it. No, I'm using the headphone only. Hello? 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 No. Yeah, it's clear? So, because of all these things, there is an, and so we can see that a lot of decisions have been taken with regard to this PIT regulations. So, what is the regulation discuss about? I mean, it talks about trading by an insider while being in possession of unpublished price-sensitive information. So, if you see the definition of insider, insider is somebody who is connected or who is deemed to be connected, or anybody who is in possession of or having access to unpublished price-sensitive information. Look at the usage of the word or, which means very clearly to be an insider, you need not have to be connected. By merely possessing or having access to UPSI itself will qualify that person to be an insider. So, therefore, one aspect is SEBI will, while it's making a decision whether an act of insider trading has taken place or not, will look at whether he is a connected person, or it will also check whether the person has had access to unpublished price-sensitive information or not. So, the regulation also adds, at one place, it very clearly says, and even the committee report very clearly brings out this fact that when the person is a connected person, then it is up to the connected person to prove, or the onus is on the connected person to prove that he is connected or he is not connected, and even if he has connection, he did not indulge in that act of insider trading, he did not have access to UPSI and so on and so forth. Whereas when SEBI is alleging, or the show cause notice is alleging, that the person has been treated as an insider because he's been in possession of UPSI or unpublished price sensitive information, the onus to prove that this person was having access or was in possession is on the regulator and not on him. So, once the regulator puts across the proof, then it is upon the person who is accused or who is, alleged to have traded, then to say that whatever has been alleged by SEBI is not correct or is correct and so on and so forth. So therefore, qualify as an insider, it should be either a connected person or in possession of unpublished price sensitive information. So that this again puts us into a position where we have to understand who are these connected persons, what is unpublished information, what is price sensitive first, and how does it qualify to become unpublished. So, to be a connected person, first of all, what we do is, whenever there is an act of insider trading that has taken place for a period of 6 months prior to that, we run a test to see whether this person was connected, associated with the company directly or indirectly in any capacity, or by way of frequent communication. Now look at the matter of Amlendu Mukherjee in Rico India Limited. Now, Mr. Amlendu Mukherjee was not an employee of the company. He was not a director of the company. He was not, promoter of Rico India. So what was he? Amlendu was only a business partner or he was having business relationship with this company in the sense that his company was the platinum partner of Rico India, and he was required to bring orders up to 500 crores every year. So that was the relationship. And what did Mr. Amlendu do? By virtue of this business relationship, he would always communicate with the persons in the financial department of the company and say this order has come from X party, order has come from Y party, or give, either it could be a buy order or a sell order, and he would direct the accounts department to make the necessary entries. It was also seen that Mr. Amlendu Mukherjee would, he had organized some vacations for, the CFO and the CEO and their families to exotic locations both in India and abroad. He had also secured an admission in a very prestigious college for the daughter of the CEO of the company. So all this, SEBI and the regulator concluded was very clear that he was connected to the company because of his business relationship and by virtue of frequent communication with the officers of that company. So therefore, to be connected to the company, it could be by way of communication, it could be by way of being a promoter, by way of being a director, by way of being an employee, by way of being in business, professional relationship. fiduciary relationship, which would mean by being a merchant banker, a debenture trustee, a banker. It could also be by being a statutory auditor, a cost auditor, an internal auditor, an IT consultant, secretarial auditor, and so on and so forth. So, is merely being in these kind of relationship, does that make the person a connected person? No. The second condition that has to be satisfied is this relationship, which has been there for the last 6 months, puts the person in a position to have access to unpublished price sensitive information, or they're reasonably expected to have access to this unpublished price sensitive information. So, two things will have to be satisfied even here. This connected person must have the relationship, which relationship enables the person to have access to unpublished price sensitive information. And however, there are certain persons who are deemed to be connected. So which means that once X is connected, certain persons who are connected to X will automatically be deemed to be connected to the company, like immediate relatives. And who are the immediate relatives? Immediate relatives would be spouse, parents, children, brother, sister, and that of the spouse, which would mean spouse's parents, spouse's brother, and spouse's sister. Now, while all the relationships are rebuttable, that in the sense that they can always say that although we are all related to Mr. X, who is the employee of the company, we have not been in communication with him for so long, or we have not actually had access to this information. It can all be rebutted, but as regards spouse, there is no question of any rebuttal, will be automatically considered to be and deemed to be connected, irrespective of the fact whether the spouse is financially independent or takes decisions with regard to investing in shares on her own or on his own without actually consulting the connected person. So this law was established, or this position has been established in Manappuram Finance Limited, where an independent director who pleaded that his wife actually invested in the shares of Manappuram when the window was closed, for which he did not take pre-clearance, saying that she was financially independent, she had her own sources of income, she would do the investments by herself and would not actually consult him or take anybody else's decision, was not accepted by SEBI and even by SAT. So therefore, as regards spouse alone, unless the spouse is legally separated or divorced, it will be always considered to be deemed to be connected. The FAQ that has been given by SEBI, that is the guidance, guidelines or guidance questions and something which has been put up by SEBI, also handles this in the same manner. And anybody who's dependent financially on this connected person will also be deemed to be connected. And anybody who consults this connected person while taking an investment decision regarding investment in securities will also be considered to be deemed to be connected. So, however, all these are rebuttable, up to the connected person to say that he is not connected or that his investment decision in the securities was not fueled by any of these connections. But then with regard to the spouse alone, I would like to reiterate once again, no question of rebuttal. It is considered as it is. There is no room for any questions at all over there. So, trading, and again, we have to remember that this regulation is giving a very inclusive definition for trading and includes pledging of securities also. So while we consider buying, selling, subscribing to the shares in an IPO or agreeing to do so is conventionally assumed as trading, we must also remember that pledging, wherein we create a charge on the shares of the company, would also be treated as trading. Therefore, what would happen is that suppose somebody pledges shares while being in possession of unpublished price sensitive information, he could still be charged under the various provisions of the insider trading regulations. So pledging also gets covered automatically under this regulation. So next important thing is, as we already know, we have said it is a trading done by an insider while being in possession of price sensitive information. So what is that information which is price sensitive? So any information which has a potential to affect the share prices materially, which would mean that huge rise and also huge fall either ways would be considered as price sensitive, and when that price sensitive information is not generally available, it becomes unpublished price sensitive information. So again, that leads us to the next question as to what is generally available. So as per the regulations, any information which is available without, to the public at large, without any limitation, without without having to ask somebody, or it is without any questions, is called as generally available. Now, at various points in time, from 92 onwards, this generally available has been debated, or rather we should say it is unpublished, which has been debated. And we have come to a conclusion that that information which emanates from the company and is disseminated by it to the stock exchange or put on its own website would be considered as generally available. That which is debated in the newspapers or, as a rumor mongering or something that is floating will not be considered as generally available. So that is a general established principle. While in the recent past, if you have seen the orders that have been passed in the WhatsApp cases by the whole-time member of SEBI, you would notice that he had made a comparison between the the flow of information in WhatsApp cases with the flow of information in Manappuram Finance. Now, in both these cases, what happened was that there were some financials, unaudited financials, which were available to the people before the actual release of the financials by the company to the stock exchange. In the WhatsApp cases, it was for regarding 12 companies which were circulating in a closed WhatsApp group, and it was emanating from a broking outfit or from a research company. While in Manappuram Finance, it was Bloomberg's analyst who actually, happened to get this financials, and it was broadcast to more than 2,000 people by Bloomberg itself before the financials were officially announced by Manappuram to the stock exchanges. Now, in both these cases, the member has made a clear distinction. While in the Manappuram case, he said that it was broadcast to 2,000, means it became so widely available that it could not be considered as unpublished, or that something that is not generally available. She has used the term not generally available. While in the WhatsApp cases, since it was circulating only to a closed group of 5 or 10 people and it was managed by the administrator, it is very clear that it was not available on a non-discretionary basis to all and sundry concerned. And so there she held that this information is classified, or what we could say is not generally available. So that is the kind of test. And to put it even more in more simple terms, if you go back to the committee report itself, the report clearly says that in case the managing director of the company were to take ill, within his room or in a board meeting where only 4 or 5 people are present along with him, that information is not generally available. While in case he falls ill in the, the reception of the company or in the lounge of the hospital, where it is known to everybody, to the public at large, where it is seen and understood and it is, it could be spoken about by the public at large, then that is generally available. So that is as simple as they could have put it in the committee report. So that will help us to determine whether there is any this thing or not. So, of course, without knowing who's the compliance officer, we cannot proceed further. So, as you will see from my image itself, the compliance officer has handled so many things as far as the PIT regulations are concerned. He is the go-to person. He or she, in fact, I should use the word she also, because we are having so many lady compliance officers now, and they handle all the queries and doubts on the code of conduct. They grant pre-clearance, responsible for window closure, and so with responsibility comes every other things also, whatever we want to add. And so you would see that there has been an informal guidance that has been given by SEBI in the matter of Kirloskar Chillers, where one of the companies belonging to the promoter group wrote to SEBI asking whether the compliance officer has the right to reject or not to give pre-clearance when they are entitled to trade in the shares of the company. And the reason that was given by the compliance officer was that there is a limit that has been fixed for giving pre-clearance to the promoters, and that limit has been exhausted. So SEBI came out or has given a reply in that informal guidance clearly saying that it is up to the compliance officer to grant or reject pre-clearances. And in case they are unhappy with the decision of the compliance officer, the only person they can complain to would be the board of directors to whom he is answerable. So, the compliance officer is the person who will decide as to whether to give, not to give pre-clearances, and is also given the responsibility of closing the trading window as and when required. And that is why you will see of late so many orders, they have also held the compliance officer responsible for not implementing the model code of conduct and ensuring that the trades of the various people in the designated persons are not monitored properly by them. So therefore, and who is the compliance officer generally? As per the LODR, it is the company secretary. It is a qualified company secretary. But while under the PIT regulations, it says any senior officer designated as such, reporting to the board, financially literate, capable of appreciating what is the meaning of compliance, and also responsible for maintaining the records, adhering to the rules, preserving UPSI, everything, and under the overall supervision of the board. So while LODR specifically says it should be only a qualified company secretary, the PIT regulations gives us a lot more of freedom and says it can be any senior officer who's designated as such. Now, we all know that no company can have two compliance officers. So it will invariably be only a qualified company secretary who can do this job of a compliance officer. And as you know, our regulation, our institute itself very clearly says that we are the gatekeepers of conscience. We are the compliance executives. And so naturally, there is nobody else who can do this job better than our company secretaries. And so therefore, although LODR again says it should be a qualified company secretary, 95% of the companies will ensure that only the company secretary of the company is a compliance officer, is the compliance officer of the entity. Now, why insider trading says, a senior officer designated as such is only because of the fact that insider trading regulations or the PIT regulations is the only regulation which is applicable to not only listed entities, to entities which are going to get themselves listed. That is, those which have filed a draft red herring prospectus with SEBI, or which are going to be listed post a scheme of amalgamation or any other scheme approved by the NCLT. And it's also applicable to all the registered intermediaries under the SEBI, merchant bankers, brokers, portfolio managers, alternate investment funds, and everybody. And it is also applicable to fiduciaries like chartered accountants, IT consultants, legal advisors, cost auditors, secretarial auditors, and so on and so forth. So because all of them need not be listed, and that all of these people also must have a compliance officer, they have, and who may not, and these intermediaries and other entities may not appoint a company secretary or a qualified company secretary in their roles. It says that it should be a senior officer designated as such. So while all listed entities will ensure their compliance officer is only a qualified company secretary, other people may designate somebody who's fairly senior and who meets all these requirements as their compliance officer. Remember one more thing, all through, I have never used the word shares, I've only used the word securities, because insider trading regulations is applicable to trading in all kinds of securities which are defined as securities under the SCRA and SCRR, which means Securities Contract Regulation Act, read with the Securities Contract Regulation rules. So therefore, if a company's only debt instruments are listed, the PIT is applicable. If it is, it's a company which is an alternate investment fund, which invests in listed securities, PIT regulations are applicable. If companies, their employees are getting ESOP shares and they have lent it for margin purposes, that is under the Securities Lending and Borrowing Mechanism, SLBS. There also it's applicable. It's applicable to depository receipts in case you have, foreign employees in your foreign destinations who are trading in your depository. It's applicable. The only security to which the PIT regulations is not applicable is the units of mutual funds. That's the only exception. Otherwise, it's applicable to every other security. So before we get into the regulations, we can take some questions now, Kushbu.
Sure. I would like to ask you a few questions which we received from the participant. One of the questions we received is, if a spouse is financially independent and doesn't consult an insider while taking trading decision, is that spouse exempted from the definition of immediate relative?
Yeah, it will, see, as I already told you, spouse is always considered to be connected or deemed to be connected to the connected person. This is irrespective of whether she is financially independent, whether she takes her own decisions, etc. The only defense that is available is, now SEBI will charge, let's say the spouse is traded, and like it happened, let's say in Mu Sigma, no, where they got separated. So, and the only defense they can take is that they have legally separated or they are divorced. Then in which case, SEBI will take the considered view and say that the trade has not been fueled by UPSI because there is no opportunity for information to flow from the connected person to his wife who is now estranged, who is now separated. So that's the only exception. Otherwise, for all practical purposes, come what may, they are considered as connected and deemed to be connected.
One more thing I would like to ask, if we make one more string attached to this relation of immediate relative, suppose one of the distant relative cousin who is supposed to be the cousin of a wife who is financially dependent is staying with that spouse, both of husband and wife, and again is privy to the information somehow. So what will be the impact of this particular?
So let me give you as an example. See, the cousin of the wife is not falling within the meaning of relative.
Yeah.
Or immediate relative, both. Okay, it doesn't fall under the definition. But let's assume the cousin has traded. Now let me take the example of Palred Technologies. What happened in Palred Technologies was, the managing director of the company was one Mr. Palam Srikanta Reddy. Now, Palred Technologies was taking a decision to hive off one of its divisions on a slump sale basis. It was planning to sell it off completely. Now, Palam Srikanta Reddy approached PwC, PricewaterhouseCoopers, to be their consultant to advise them whether this was financially viable, when it should be done, how it should be done, etc., etc. Now, this exercise started in September 2015 and ended in August 2016. Now, during this period, this entire period of 11 months is UPSI period because the company is considering a major decision to hive off one of its decisions on a slump sale basis. It's going to sell it off. So, at this, and as soon as it was notified, it was made public, the share prices went up as it was of any of these kind of decisions. So, SEBI investigated and it found that there were certain people who had traded during this period of 11 months. Some people who had bought. I'm coming to your question now. So, it noticed that there were two ladies who had traded who, were related to the managing director as a distant aunt and his cousin. Okay. One was his aunt and the other was his cousin. Now, both aunt and cousin don't fall within the definition of connected, of relative or immediate relative as per Companies Act and SEBI regulations and SEBI Act. But however, SEBI considered them to be connected persons and charged them accordingly. Why? Because they looked into the trading pattern of these two ladies. Now, these two ladies had never traded in shares till September, October of 2015. They never traded. They didn't even have a demat account. So they opened a demat account in the end of September and started trading in the shares of only Palred Technologies. They had bought only Palred in October, November of that year and sold off all this in 2016, after which there was no trading again in shares. They never invested in shares. So the trading activity was so suspicious. So therefore, they were considered as connected persons, and even now there are several orders that are being passed. It has been upheld by SAT also in several matters. So this is how SEBI decides whether, there is a connection or not. So it's up to SEBI to put everybody into the net as connected persons. Up to the connected person to prove that they did not have access to UPSI or their trades were not fueled by UPSI. I can also give another example.
Yeah, sure.
Rasi Electric. Yeah.
Ma'am, just I want to ask one thing. You mean to say whatever you have explained, the onus is on the connected person to prove him, not on the SEBI. Yeah, okay.
See, there are two things. Again, connected person by definition, if the person is connected, the onus to say I am not connected or I did not trade while being in possession of UPSI is on the connected person. But if SEBI is alleging insider trading has been done by somebody only because they have had access to, SEBI says you have had access to it, then it's up to SEBI to show that they have had access. And how? And how they have done the insider trading.
Right. One more question is there, ma'am. This is whether a person being an administrative head, such as head of IT department or human resource department, or a general manager or chief sales manager said to be within the meaning of an officer for this purpose?
I won't say officer. Shall we replace it with designated person? Okay, because that is what SEBI is using now. So, as far as the regulations go, which I will be actually discussing a little later, but I will just, for the sake of it, just be like, take a small explanation over here. Anybody whose role and whose function puts him or her in a position to have access to unpublished price sensitive information will be treated as a designated person by the regulator. So, there have been cases like, for example, in ITC, where the head of the stationery division, that is the one who designs what should the stationery be like. Should it be white in color or pink in color? Should it have this watermark or should it have this particular picture or this boundary? Was held as a designated person by SEBI but was set aside by SAT, saying that this position does not put him in a position to have access to UPSI. So the test is the role, the functions that are being done by this person, whether it makes him have access, him or her have access to UPSI. So HR head may not have access, so cannot be treated as a designated person. Happened in Wipro.
All right, ma'am. We have. We can now proceed to next of our slides.
Okay.
Then we will take up another
next set of
question and answer.
Yes. So the regulations. Now, Khushbu again in the introduction, she said it was one of the most lethal, most dangerous regulations. Or she gave a lot of adjectives to this regulation. Yes, it is one of the most lethal regulation, but it's not a voluminous regulation. It's a very small regulation. Regulation is only this much. It's only these three, nothing more. That is what is prohibited. Because if you look at the regulation, it says prohibition of insider trading regulation. So there is no room for anything else. Insider trading is prohibited. It's a criminal offense. That's it, full stop. So what are we prohibited from doing? Communicating UPSI, procuring UPSI, trading while being in possession of UPSI. So as long as these three things are taken care, there can be no room for insider trading at all. But unfortunately, that doesn't happen. As recently, you must have seen 2 months ago, SEBI passed an order on the employees of Infosys and 3 other persons. What had happened in that? The person in the finance department, legal counsel of Infosys, had communicated some financial details just before the declaration of the results to 3 persons outside the company who are, private equity players and merchant bankers and so on. And they had traded on the basis of this UPSI. So that, and accordingly SEBI had gone ahead and levied a penalty. Procuring. So anybody who, pals up, who just comes and says, tries to be friendly, tries to pick up information. Even it could be the person working in the same company, but he's not required to have this information. Could be asking for what's happening, what are the future ideas, how are the financials, so much. All this is only fishing for information. Procuring is also prohibited. The worst of the 3 would be trading while being in possession of UPSI. Like it happened recently in Divi's Labs. What happened in Divi's Labs? There was one employee who, while the company was considering their FTA relaxation, that is, Divi's got a clearance, a thumbs up from the FTA in the United States to sell their products from their Visakhapatnam factory in the United States. So while a group was discussing how to handle this, what are the disclosures to be given, what are the other formalities to be complied with, one of the employees who was privy to this very sensitive information that FDI had given clearance, because the UPSI time itself was only from 4:23 a.m. to 11:30 a.m. of that day, because 4:23 a.m. was the time when the managing director got a email from the advocate in the United States, and 11:30 was the time when the company disseminated this information after discussion to the stock exchange. And in all, only 8 people knew this. And still, this employee who happened to be attached to the whole-time director and who had access to that email had traded at 9:15 on the same day and squared off and his positions within 4 days, making a profit of 1,32,000. So this was taken very seriously by SEBI, and the penalties that have been levied are disgorgement of 132, fine for trading while being in possession, debarring him from trading in any security for 1 year, and in the securities of Divi's Labs for a period of 2. So the regulations clearly prohibit these 3. But then you will ask me, sometimes, it has been done by mistake. It has been done because we have been reckless. I had a case where one of my clients, he actually traded in the derivative segment when it was not permitted. It cannot be traded in the derivative segment. And when the AO before whom he appeared asked as to why he traded in the derivatives, he said, I wanted to have the kicks. I just wanted to know what it felt like to trade in derivatives, because I have never traded in derivatives. So that is sheer recklessness, trying to be speculative. No. It is not an excuse. Some people say, I didn't understand. I don't know the regulations. Ignorance. I just didn't know these regulations existed. Doesn't matter. Some people will say, I bought only 50 shares, 100 shares, 500 shares. I made a loss. Nothing matters. As long as it is shown that the person has traded, and which is not in consonance with the regulations, and it is alleged that they have indulged in the act of insider trading. So therefore, there is always a question. I am handling UPSI continuously, or my set of people in the organization, many people are handling UPSI. They are all handling financial results or something to do with a merger or takeover, a buyback, a fresh issue of shares, bonus issues, dividend, backing a big order. So many things we are always handling. So are we not supposed to share it with anybody else? Because I said communication is prohibited. Sometimes, as a part of our work, the statutory auditor or the secretarial auditor may want to ask for some information. So is procuring Krutuli brand, is not permitted at all? The merchant banker who's handling your due diligence, he may say, I want some information. He would like to have it because that is required for carrying on the regular activities, so for legitimate purposes. And so therefore, to handle this UPSI, we have to keep 3 things in mind. Always share it only on a need-to-know basis for legitimate purposes. And there are, of course, the control mechanisms called the 2 codes, which are there enshrined in the regulations. So let's take them one by one, because these are the steps that the company can take to prevent insider trading to take place. So because, as I said, insider trading is prohibited, but some steps that we all can take as compliance officers, as employees, designated persons of the company, to prevent an insider trading or from taking place or getting into a trap and to say, oh my God, we have by mistake we have done this and we are facing this action. So let's take them one by one. So first and foremost, remember, whatever be the information that is unpublished, that is price sensitive, it can be shared only on a need-to-know basis when it is required to do our work, furtherance of our work. Only for that purpose can it be done. And the regulation itself gives 2 exceptions for it. One, it says whenever there is an open offer, a takeover, then with the prior approval of the board of directors, who clearly say that the sharing of this information is in the best interest of the company, You can share whatever is even price sensitive, whatever is unpublished with the merchant banker and the team which is working on this information. Or for any other transaction, again with the prior approval of the board, if it is in the best interest of the company, but provided it is disclosed 2 days prior to the transaction being entered into the stock exchange. So therefore, the regulation itself says, go ahead. If it's needed for your work, go ahead and share it. To make it even stronger, the regulation has now required that you must have what is called as a legitimate purpose policy. A policy which will determine what are the legitimate purposes for which we can share unpublished price sensitive information. So we list down what are the purposes for which we do it. And also it says who are the people with whom you can share this information, whether it's partners, whether it's collaborators, joint venture partners, merchant bankers, auditors, your own bankers, solicitors, IT consultants, anybody. Okay, so it can be for anybody, with anybody. Only thing is that we must very clearly say that we are to enter into a non-disclosure agreement or an NDA with these people, which will clearly set out that this is the reason we are sharing this information with you. By virtue of you having access to this information which is unpublished and which is price sensitive, you are now treated as an insider, and therefore you are governed by the various terms and terms of the insider trading regulation. You will have to treat this information as confidential and will not trade while you are in the securities of the company, while you are in possession of this information. So by virtue of this, what happens is the company secretary, the compliance officer, the company itself, we are safeguarded when that person happens to trade or communicates it on purpose or inadvertently or by negligence or whatever, because we have an NDA, we are covered by that and also by the various terms that are provided in the legitimate purpose policy, which allows us to share whatever be this information with which set of people. So, that gives you the room, the headroom to work without any fear and share whatever be the information. Furthermore, SEBI has also amended the regulation to bring in what is called as a structural digital database. So here there is a confusion. Many people I have understood in the last few things, particularly when we were doing the audits, they feel that this digital database should only contain a database of the outsiders with whom UPSI is being shared. No, this database is a database which will have to be maintained digitally, which would mean that you don't make a physical entry in a register. It should contain the names and PAN number and designation of all the persons, both inside as well as outside the entity with whom UPSI is being shared. So how do we maintain it is we have now currently many of them I know are maintaining it in Excel sheet, fair enough, but it should say what is the nature of the UPSI. So let's say we start off with the unaudited financial results for the quarter. So June 30th quarter is ended. July 1st, the UPSI is created because, that is the day we actually start off looking at the financials for the previous quarter. So who generates it first? The MIS reports who generates it at the first stage. So we'll start with the name of the person who generated this UPSI, designation, PAN number, what date, what time will have to come. And as far as possible, this date and time should be automatic. There should be no physical element or, manually entering this, into this database. So if it can be done automatically, yes, we are 100% in compliance with the system. But I know many companies are struggling as to how to make this automatic and it is being physically entered, which actually defeats the very purpose for which SEBI has told that you should maintain a structural digital database, because they want to have audit trail and time stamping to know how the information actually went from desk to desk or from person to person within and outside the organization. So as soon as this person has created MIS and shared it with the next set of people, you make the entry saying X has shared it with A, B, C, their PAN number and their probably unique identification number along with the time and the date of sharing. And once they have worked and they forward it to some other persons, then that will be shared. And so it goes up to CFO, MD, statutory auditor, company secretary, directors, and finally, and as and when it is disseminated, it stops, it ceases to be an unpublished price sensitive information. This has to be maintained in-house. You cannot store it on some cloud. You cannot store it on an external database. You cannot give it to an outside consultant to store it for you. And it should be maintained for a period of 8 years. So it is in line with your preservation of documents policy of the LODR. Remember there, we are saying that there are certain documents which have to be kept for 8 years and some which have to be kept for life. So this is one document which will be preserved for a period of 8 years. So accordingly, this has to, your preservation of document policy also has to get amended to include this structural digital database. Okay. So now the regulation again says at one place, suppose somebody has traded while being in possession of UPSI, they can demonstrate their innocence by using this defenses, or it can say only defenses. Remember, it is only to put up a defense. And what I'm trying to distinguish is some people are under the mistaken impression that if it's an off-market interstate transfer amongst insiders, then it should not even be treated as a trade. No. SEBI says we will still treat it as a trade. We will still charge you under insider trading regulations of having traded while being in possession, but the persons accused, in case it is, the two of them are insiders or they have done an off-market interstate transfer, which, and both of them had the same set of information. They both took the same conscious decision to buy and sell on the basis of the same information. Both of them have given a disclosure to the company within 2 working days of entering into this transaction, and company in turn has intimated the stock exchange within 2 trading days of this particular transaction. If all these are satisfied, then probably we would use it as a demonstration of innocence, and we might probably, let go, drop the charges. But the company or the compliance officer or the individuals concerned cannot take it as a matter of right and say that it is an off market, so it cannot be treated as a trade. This is only as a demonstration of innocence, as a defense mechanism that is available. Again, any transaction that happens between 2 persons, here they have not used insiders, 2 persons who are in possession of this information, they have used the block deal window of the stock exchange, that window which is available for 15 minutes before the exchange opens for regular trading. If the trade has taken place there, then yes, that also can be used as a matter of defense. Now, in both these cases, SEBI uses, and since the word insiders is used, and here persons who are in possession, suppose let's say these 2 persons got the information because they were merchant bankers, or they had got this information because of the exceptions that are provided. As what I said is open offer, there is an exception that is provided, or any other transaction where sharing is permitted by the board because it's in the best interest. Now, those people cannot use this block deal window to trade. That would be an abuse of the exception that is provided, and that cannot be treated as a demonstration of innocence. Pursuant to a statutory obligation or a regulatory obligation, suppose there is an order by SEBI or MC or tax authorities which says that the shares held by this person has to be sold, or this person has to buy the shares back because his previous action has caused a loss to somebody else, then it will be done, and that can be shown as a matter of innocence. In case somebody is exercising their ESOPs, employee stock options, which have been given pursuant to a plan which has been approved by the shareholders much earlier, the price at which the options are to be exercised are also fixed much earlier, then there is no problem. And this is particularly relevant to intermediaries, where the person who took the information or took the decision with regard to trading and the person who got the information, the UPSI, they are 2 different people. The person who is trading is in X department. The person who got this UPSI, who's in possession of this UPSI, let's say he's doing research, or they are the ones who make the recommendations, etc. That's a different person. And there is Chinese walls between the 2 people actually existing, and information did not flow from X to why? Because there is clear-cut Chinese wall between the two departments. So those people are also exempted. And if it is pursuant to a trading plan. So these are all excuses or circumstances which can be used to show that whatever act was done was not an act of insider trading. Khushbu, should we finish trading plan or shall we take questions?
Just one more question from the structural digital database.
I was expecting a lot of questions there. Yeah.
Actually, this is such a critical element of this insider trading, which is recently introduced by SEBI. So one that suppose that structural digital database, the company has taken this outsourced from the third party vendor, right? And the server is on the third party vendor, but the company is operated the login and all from the inside the company. So whether it will be fall
it's a violation. Yeah, it's a violation because your data is getting stored on the server of an outsider. If you look at the guidance notes that have been issued by SEBI recently, they've even said Amazon Cloud is not permitted.
Okay.
So cloud, cloud itself is a third party only because you're keeping your data stored elsewhere so that it remains safe. But it does not mean that somebody else cannot access it. If you give a password or they also break some, a lot of hacking, etc. goes on. So therefore, when you give it to the third party vendor, that is clear violation, not permitted.
One more thing, that this requirement of, as you already explained, is also applicable to intermediaries and fiduciaries. So, can you explain it a little bit more on what means the detailed implication of this insider trading, whether the employee of intermediaries also falls under this structural digital database?
Yes, absolutely. Very much so. Why? Because let's take an intermediary, merchant banker. Okay. What does a merchant banker do? Merchant banker handles IPOs, rights issues, sometimes preferential, but generally no. Follow-on public offerings, also all public issues, rights issues, QIPs, buybacks, open offers, delisting, everything. So let's say they have some 15 clients handling different things for 15 different entities. How much of price-sensitive information is there? Company planning to go for a public issue, or company planning a rights issue, company planning a QID, means more money, their investments are going to double, triple, share prices will go skyrocketing. If they are planning an open offer, taking over some other company, up or down, share prices may go anywhere. So therefore, lot of UPSI floats around in a intermediary. Stock broking, so much. And a portfolio manager, his decisions to take, investment decisions, it can be used by the employees to make money themselves. Investment advisor, generally not much, but to an extent, not really much. But all these intermediaries are handling a lot of unpublished price-sensitive information, and so therefore they also need to have a digital database saying what kind of UPSI came in, who handled it, who created it, who it is shared with, and till such time the particular assignment is completed. So it's equally applicable even to a statutory auditor. We are doing fiduciary, that is, we are doing an audit. So information has come from the company, and so therefore that team which is working on is handling UPSI. So till such time the company declares the results, makes it known to the stock exchange. All these people are handling unpublished price sensitive information. So a digital database is required even in a fiduciary, everywhere, whichever company is handling UPSI.
One more question I would like to ask, ma'am. Can you please explain a little bit more about this block deal window? Because many of us are actually, what is block deal window? There is so many confusion going on.
Okay. So there are two terms that are used. One is bulk deal, the other is block deal. Okay. Now, you must be aware that exchange is open for trading from 9:30 in the morning to 3:30 in the evening. Right? So, now let's say promoters want to sell a big chunk of shares. So some, 30 lakh shares or 35 lakh shares. Now if you put it in the market and let's say these promoters want to sell these shares specifically to somebody else. So let's say I want to sell it to you. Okay. I want to sell it to Khushbu, all 30 lakh shares. Now if I put it in the market, Khushbu will definitely not get the 30 lakh shares. It will happen that she may end up getting 20 lakh shares while 10 lakh shares may be picked up by so many other people. So to ensure that Khushbu gets the 30 lakh shares and at the price which we have agreed upon, we use this window. We seek the exchange clearance the previous day through our broker, and before exchange opens for trading, of course it is subject to that upper circuit limit, etc., the pricing and all that, but still we both will do it on that window so that the entire 30 lakh shares that I am selling will go only to Khushbu, and Khushbu will get all the 30 lakh shares that I intend to give it to her at the price which we have agreed upon. That is block deal. So nobody else gets into the system. Whereas bulk deal is there is a certain percentage of shares beyond which, say 2% in some securities, 5% in some securities during exchange trading hours. If so many shares are traded, then that deal is called as a bulk.
Thank you. One question is you have explained very beautifully this unpublished price sensitive information. Suppose a company is there. There are as many as 120 branches all over the across the country, and in the meantime, that promoter or that main managing director has gone for a long vacation to an unknown destination. What happens? There is a fire broke out in a very small branch of that company. So whether we can hold it as a oopsie?
Now you are crossing over to the LODR regulation. Okay, so there's a fire. Now LODR regulation 30 of LODR has put certain information which has to be disclosed, which is Part A, Para A, Schedule 3, and there is Part A, Para B, Schedule 3. So if your fire falls within Para A, you have no choice. You have to disclose it. If it falls under Para B, then we have to check whether this can, is material or not. Whether it is, the company must have a materiality policy to determine whether this event is material enough to be reported or not. So therefore, they will take a call. There is supposed to be a team which decides whether it is material or not. So irrespective of whether MD is there or not there, that team will decide and make a disclosure. Now, whether it is unpublished, once it falls under Regulation 30, UPSI and Regulation 30 are like parallel lines. They run together. And you cannot say anything that is under Regulation 30 will definitely have the nature of an unpublished price sensitive information. And suppose, let us say, somebody knew about it and they sell shares before it is disseminated to the stock exchange, then there has been an act of insider trading. Because they know the moment it is notified, this fire which has gutted, let's say their factory or their office or whatever, it's going to result in a big fall in the share prices. So that is how we have to draw conclusion.
Thank you, ma'am. Now we'll proceed for your further presentation.
Yeah, okay. So let's look at the trading plan. If we had a physical session now, Khushbu, everybody would have had a very strange face. I can see some people smiling, some people will be skeptical. They say, what is this? Why trading plan? I can't receive any responses. So at the next break, please give me the responses. How many of them feel that trading plan is successful in India? Okay. We'll have I really miss a physical session for this particular slide alone. But
yeah.
But I can't help it, and so let's keep it as much as lively as possible when we are discussing trading plan. All insiders are entitled to have a trading. Okay, that means it's not only the promoters, it's not only the directors. Even, that all the designated persons or VP, senior VP, everybody can have a trading plan. In fact, insider, even the statutory auditor is considered as an insider because they are having access. He can also have a trading plan. So anybody who's having access to our UPSI can have a trading plan. That's how broad it is, okay? So all insiders can have a trading plan. The only requirement is you have to drop the plan for a period of 12 months and say what is the value of securities or the number of securities that the person intends to trade and the type of trade, whether it's a buy or a sell or a combination. And the compliance officer will vet it, will go through it, and will come to a conclusion, will satisfy himself or herself that the trading plan is not being used for market abuse. The person who's submitting it is not having access to UPSI, and they can clear this trading plan. The moment it is cleared, it has to be disseminated to the stock exchange. And we have to have a gap of 6 months from the date of dissemination to the time when we start to trade in accordance with that trading plan. No two trading plans can overlap, and we must strictly adhere to what is specified in that trading plan. Okay, so which also gives you this thing. Once the person has given trading plan, no need to take pre-clearance. Contra trade restrictions will not apply. Surprisingly, you will see that only about 5 to 6 companies have made use of this trading plan so far in the 6 years. And I have also undertaken a study to see whether once the person has given the trading plan, whether the trades have been executed in accordance with this trading plan. Surprisingly, no. Nobody has complied with that. Why? What could be the possible reason for this? Is because there are certain restrictions that are associated with the trading plan. Number one, although it says you don't need to have, pre-clearance, no contra trade restrictions, window closure restriction will not apply. That is also there. Okay, window close. So that means when the window is closed, they can go ahead and trade. No, it does not work that simply. There is another clause here which says that for 20 trading days prior to the financial period, up to two trading days after the financials, unaudited financials for the quarter or the financials for the whole year are disseminated, the person cannot trade. So let's take a simple example of March 31st. Okay. Now, March 31st is year ending. So 20 trading days prior, and you know how March is. You will have we will have Good Friday, we might have Holi. So some holidays will definitely be there. Saturday, Sundays, anywhere there. So 20 trading days would mean by till 4th of March, the person has to stop trading. Now from 4th March, results are declared on 30th May. We are taking the maximum possible. So then for 2 trading days thereafter, 31 and 1,
I think ma'am has, there is some network issue, so she has been disconnected. Stay tuned with us. Ma'am will be logging soon.
between?
No, we didn't hear you at all because I think you have logged out all of a sudden.
Is it visible? I will cover trading plan once again. Yeah? Yeah. So, as I was telling you, trading plan is a plan that is given by all insiders who are entitled to, who are in possession of UPSI. So, what happens is it gives them a kind of immunity to trade while being in possession of UPSI. Despite that, it's not very popular in India, while it is very, very popular in the West. So as per the PIT regulations, all insiders who have a trading plan in their mind must submit a trading plan to the compliance officer, giving clearly the value or the number of securities that they intend to trade and the type of trade, whether it's a buy or a sell, that has to be given. And this must be given for a minimum period of 12 months. Hello? Can you hear? Can you hear me?
Yeah, ma'am. Your voice is audible.
Yeah. Okay. Because I was not getting any this thing, so I was no information, not on the screen in the bottom. So that's why I was wondering whether it's getting shared. So yeah. So this trading plan must be for a minimum of 12 months, and the moment the compliance officer is satisfied that the plan is not used for market abuse and that it is being given by a person who is not in possession of UPSI, will definitely clear the plan, and then once it is cleared, it has to be disseminated to the stock exchange. Now, from the date of dissemination, for a period of 6 months, nobody can trade. That person who has given the trading plan cannot trade. So there is a cooling period of 6 months from the date of dissemination to the actual use of that trading plan. Now, this cooling period is because there could be some other UPSI that the person may be having, and that should not be used, or that should not come in the way of trading in the shares. And no two trading plans can overlap. So when he is giving the next trading plan, he should ensure that the trading plan starts after the previous trading plan ends. And once the trading plan is communicated, he must definitely adhere to the trading plan. However, it's been seen that this trading plan policy is not very popular in India. And also, SEBI has a lot of relaxations as far as the trading plan is concerned. Number one, it has said that no need to take pre-clearance. There is no need, contra-trade restrictions will not apply. No, you can trade even when the trading window is closed. Even that relaxation has been given. But however, although that relaxation is given, you will see that the person cannot actually trade for 20 trading days before the end of the financial quarter until 2 trading days after the results are made public. Which means that, let's take an example of a March 31st quarter. So from 20 trading days from March 31st would mean from about 3rd or 4th of March, the person cannot trade until 30th May, the results are made public, till 2nd of June. Now, June quarter again starts 30th June, 20 trading days before, which will mean by June 4th, again, the person cannot trade until probably August 17th, because 14th August is the date when the results are again made up. So, given that, if you look at each quarter on quarter, you will end up seeing that the person can trade only for about 20 to 25 days during a year, although he has given a trading plan for the entire year. During this period, it's very difficult for the person to get the price or to get the number of shares that the person intends to buy or sell. So because of this restriction, they are not able to adhere to the trading plan. And so therefore you will see about 5 to 6 companies only have made use of it. And when I ran an analysis to see whether they have been in compliance with the trading plan, very surprisingly, no. All of them, except 1 or 2 companies, all of them have not complied with the number of securities that they intended to buy or intended to sell. And so that's probably because of the practical difficulties that they are being faced with. But this trading plan concept is very, very popular in the West and is used by many of the entities, many of the promoters and KMPs as a shield, as a defense mechanism to say that their trades are in accordance with the trading plan that they have submitted and is not fueled by being in possession of UPSI. So, while we have looked at these defenses and other things that are available, the next important thing that all companies have as a method of preventing insider trading is the codes. One code is the code of fair disclosure, which has to be hosted on the website of the company, which essentially talks about the prompt dissemination of unpublished price-sensitive information, which gets, disclosed selectively to certain people. In case somebody happens to, by mistake, talk about an UPSI to X or Y, and he should not actually know about it, then it has to be disseminated promptly to all the people, all stakeholders, all and sundry, without any distinction. In case there is a market, in case there's a newspaper report or a market rumor, and exchange is asking the company for verification of the same, the code must discuss as to how they are going to give appropriate and fair responses for the same. They must also ensure that all information shared with analysts, research personnel, institutional investors are all in line with what is generally available and not unpublished price-sensitive information. Transcripts of the various court calls that we have with the prospective investors and analysts must all be available on the official website of the company as early as possible and not at the end of 45 days or 60 days, because many companies they say that it's very difficult to get these transcripts and it takes that much of time. So efforts should be made to bring it as early as possible and put it on the website. In fact, LODR recent amendment of May 5th of 2021 also talks about this and puts casts a responsibility on the company to put these transcripts immediately, not later than a week, I think, on the website of the company. Of course, it also calls for the designation of a senior person in the organization as a Chief Investor Relations Officer, and who will be dealing with the dissemination of information and disclosure of unpublished price-sensitive information. Now, while we are at this code, intermediaries cannot do much with this code. It will essentially be a listed entity specific code, although the regulations does not make a distinction and says the code is applicable even to intermediaries. So as far as possible, they can adhere to what is there in this, but it becomes very difficult for a fiduciary or for an intermediary to have this kind of a code and put it on their website. So what will be applicable to all, irrespective of being an intermediary, fiduciary, etc., is the next code, which is the code of conduct, or the model code of conduct we call it, or the code of conduct which is there to monitor the trades of the designated persons, or for the prevention of insider trade. So every entity which is to which the PIT regulations are applicable must draw up a code, and that code must be modeled in accordance with Schedule B for listed entities and Schedule C for the intermediaries and fiduciaries. And in case a company does not have a code, then the board of directors and the compliance officer of the company or that entity will be held responsible and proceeded against accordingly. One company which I can remember is Falcon Tires, which actually said they had a code of conduct, but then the code of conduct was not in accordance with the SEBI requirements, and so the adjudicating officer had actually levied a penalty on the compliance officer as well as on the board of directors for not having a code of conduct. However, SAT had set aside that order, very clearly saying that although it was not in line, we should have we should look at what is the intention, and the company had the intention of having a code of conduct. So therefore, it's an important thing for companies to have that code, and if they don't have, the regulator can proceed against that company. So first and foremost, all companies must have the compliance officer, and the compliance officer, in consultation with the board of directors, will identify who are the designated persons. Already Kushbu asked me this question, whether the head of the organization or of a particular department can be treated as a designated person, for which I had said designated persons are identified on the basis of their role and the function that they discharge, and whether they have access to UPSI or not. So employees of the listed entity or of the fiduciary or of the intermediary are called as designated persons based on their functional role and whether that role provides them an access to unpublished price sensitive information. Same thing with employees of material subsidiaries of listed entities, who again, based on the functional role and their access to UPSI, will be treated as designated persons. All promoters of listed entities will be treated as designated persons, and our promoters would mean, all promoters means whether it's a company, whether it's an individual, whether it is an NLP, whether it's a partnership firm, all are treated as designated persons. They don't make a distinction. Then whereas for intermediaries or fiduciaries, only promoters are who are individuals, and those which are investment companies will be treated as designated. The CEO or CFO of the company, CEO of the company, and 2 levels below the CEO of the company, intermediary, fiduciary, irrespective of what their role will be or not, whatever it is, whether they cannot take a defense saying that I did not have access to unpublished price sensitive information. As long as it is 2 levels below the CEO, automatically these people are treated as designated persons. And all support staff of listed entities, whether that is in the finance department, secretarial department, IT, the information technology, who put all the systems and codes and everything in place, they're all treated as designated persons because they're all having access to unpublished price sensitive information. So secretary of the managing director, driver of a managing director could also be treated as designated persons because they are in a position where they may have access to UPSI continuously because they are, in a position to listen to their, to the managing director, speaking to many people and sharing lot of UPSI. So irrespective of their role, irrespective of their position in the organization as a support staff, because they are having access, they could be treated as designated persons. So therefore, what I'm trying to tell you through this is that all designated persons will essentially be insiders in the organization. They will all be only employees of the organization, and they will, it will be more company specific, company centric. While connected person will include the designated persons plus all other persons who are connected to the company by virtue of their business relationship, financial relationship, because of their, access, because of their frequent communication and the access to UPSI of that particular company. So while all DPs will be connected persons, all connected persons need not be DP. While insiders will include designated persons, connected persons, plus anybody else who has had access or who's having who are in a position to have access to unpublished price sensitive information. So while all insiders will include connected persons and DPs, so all DPs, connected persons can be treated as insider. Now all insiders need not necessarily be DPs or connected persons. So that's how the curve or this thing goes. So what does this code actually say? First and foremost, do not share any information except on a need to know basis. obtain pre-clearance for all the trades, not only for the trades of that particular person, but also for the trades of their immediate relatives. So in Biocon, recently, one employee had not taken pre-clearance for the trades. They were fined 3 lakh rupees. So therefore, even in Mannapuram, I was telling you how he had not taken pre-clearance, the director for that of his wife, and also traded when the trading window was closed. So was fined about 10 lakh rupees. So SEBI takes this very, very seriously. So pre-clear, and it also helps in the sense that when an employee approaches the compliance officer for pre-clearance, compliance officer knows whether the person is having access to UPSI or not. So accordingly, he may give or he may grant or he may refuse to grant pre-clearance. And so therefore, and remember, this pre-clearance is valid for 7 trading days. Trades have to be executed within that period of time. Companies can put a shorter time saying that executed by 3 days or 4 days. I know many companies would say it's valid only for 3 trading days. And in case the trade has been executed, confirmation has to be given to the compliance officer with a copy of the contract note that the trade has been executed. In case it is not executed, then the pre-clearance expires and then the person has to seek clearance once again to do the trade. Do not trade when the trading window is closed. Responsibility of the compliance officer, of course, to close the trading window, and they will always communicate that the trading window is closed. But they have to ensure that the designated persons or all the others, even the statutory or the fiduciaries and everybody does not trade when the trading window is closed. Normally closed from the first day of the financial quarter until 48 hours after the financial results are notified. However, in case the company is handling a sensitive matter like a merger or a takeover of another company or a big order or handling a license for a new activity, and it's in the process of getting a license. So when these things are happening, it may so happen that certain set of people are handling this unpublished price sensitive information. So the compliance officer can selectively close the trading window for these people to ensure that they do not trade in the securities of the company because they are handling UPSI. However, when the trading window is closed, interstate transfer amongst insiders off market can take place, provided they are, they have communicated after the transaction 2 working days to the compliance office to the company in turn within 2 trading days to the stock exchange. It should not read as bulk deal; it should read as block deal. Any deal done to the block deal window of the stock exchange by the insiders can be done even when the window is closed. Participation in a rights issue, participation in an open offer, and asset regulations, participation in a preferential allotment, in an exit offer pursuant to a delisting offer, in a buyback, all this can be done when the trading window is closed. Exercise of options for conversion into shares when the window is closed can be done, but once the shares have been obtained after conversion, cannot be sold when the trading window is closed. So exercise is permitted, while sale of those shares when the window is closed is not permitted. Creation of pledge with proper pre-clearance is also permitted, but necessary pre-clearances have to be taken. No contra trade for a period of 6 months, which means that if you have a buy, no sell for 6 months. If you have a sell, no buy for a period of 6 months. A series of buys from the last buy, no sell for 6 months. Series of sells, no buy from the last sale for a period of 6 months. Exception is only wherein if you have got shares by conversion of the options, that's the exercise of options, then although we have got shares, which is like a purchase transaction, those shares can be sold within a period of 6 months immediately. Which means that, let's say, the director of a company is already holding 3,000 shares. Now he gets 2,000 shares by way of stock options. These 2,000 shares can be sold. But the moment these 2,000 shares are sold, cannot buy again for a period of 6 months. Same way, if somebody has participated in a rights issue, now indirectly this regulation is put in a lock-in, although there is no lock-in for rights issue under the ICDR regulation. So if we participate in the rights issue then for a period, since that amounts to a purchase, cannot sell shares for another period of 6 months. So that is a kind of a indirect lock-in that has been put in by the PIT regulation. Many times what happens, people, trigger or attract the provisions of this regulation because of panic reaction. Many people use the mobile to trade, and a very small instrument, instead of buying, they press sell. So, there is a buy, there is a sell, so that is an opposite transaction. In a panic mode, they reverse the transaction, so that becomes another opposite transaction. Or sometimes they don't intend to sell at all, and by chance, because of a press of a button, it becomes a sell, which they didn't want to do. So, in types of panic reactions, better to stop the trading then and there. Then compliance officer will have to be contacted and they will take the necessary decisions. So many employees, many designated persons actually end up doing this opposite transactions by way of panic and not actually on purpose. So the compliance officer will do the needful way and help the person actually handle this kind of situation. And so like MD himself had done a lot of opposite transactions, at least on 15 different occasions. So not only was the MD fined, why I had taken this example was the company secretary and the board were also fined by SEBI because they had failed to monitor the trades of the designated person and stop the person from trading. And so therefore they were also fined. This code also requires certain disclosures. One, on becoming a director or a KMP of the company, they have to give within 7 days, they have to give their disclosure to the company. And designated persons, when they trade beyond 10 lakh rupees in a calendar quarter, must give, disclosure within 2 trading days to the company, and company in turn must give the disclosure to the stock exchange within 2 trading days. Now, or on becoming aware. Now, many companies, what happens is they wait for the disclosure to come from the persons who have traded. Now, recently, you must have seen the order of Vian Industries, where the company had not made a disclosure pursuant to the acquisition of shares by its promoters in a preferential allotment. So now the company took the plea that they were not aware because they did not know, because the disclosure had not come from the persons who had to make the disclosure. Now the adjudicating officer has levied a penalty on the company, saying that one, benefits would have definitely revealed that the shares had been acquired by the promoters. Number 2, preferential allotment was done by the company. The company is very much aware as to who are the allottees. So they are in a position to know who has received the shares. So therefore, there is no excuse that they did not know. So if the company does not receive the disclosure as a compliance officer within 2 trading days of knowing that this happened, must make a disclosure to the stock exchange. Again, many people ask the question that the transaction was a gift transaction given from one promoter to another, from the father to the son or grandfather, grandson. So in that case, do we make a disclosure? Yes. Why? Because it is not the value of the transaction that is considered, but the market value of the shares that are involved that is looked at. And so therefore, if the market value of the securities that are transferred or amongst them is exceeding 10 lakh rupees, yes, they have to make the disclosure. Apart from that, annually, many companies take disclosure of the holdings of the designated persons. They also must take, as per the regulation, of the holdings of their immediate relatives, of the PAN number, mobile number of the immediate relatives, and also of persons with whom these people have material financial relations. And who is the person with whom the material financial relationship exists? When one party, it could be the designated person or the opposite party, is receiving not less than 25% of the annual income of the designated person in the last 12 months, by way of loan, by way of gift, by way of anything. But if it is on arm's length basis, they say it is not applicable, but I really do not understand what this arm's length basis is. So therefore, we should assume that as long as there is a transaction between the 2 people, wherein there is amount involved is more than 25% of the annual income of the designated person in the last 12 months, then all the PAN number and the mobile number of that person must be collected and kept in the database annually or as and when there is a change. and from the designated person at the time when the person is joining, the name of the education institution from which they have graduated, and also the details of his previous employment. At all times, adhere to the internal code and must always adhere or keep in mind the Chinese wall procedures. There should be an inside area where all the price sensitive information is handled. Then also the court must discuss how people from outside will get into this inside area. And once they are brought inside, how to sensitize them, how to tell them that they would be treated as insiders and that that they cannot communicate unpublished price sensitive to anybody else. And in case they trade while being in possession or they communicate, they will be proceeded against these regulations. So anybody violates this code of conduct, then this matter will be referred to the audit committee. There will be certain punitive action. It could be in the form of a warning, it could be in the form of a fine, it could be in the form of a clawback, taking back some bonuses and some other payments that were made, disgorgement of the profits that were made, or anything else which comes to the mind of the audit committee. Also, now the procedure is that whatever is selected will have to be sent by way of NEFT to the IPEF, that is Investor Protection Education Fund of SEBI, and the stock exchange must be informed of the action that has been taken. So, Khushbu, should we take questions now before we go on to the last 2 slides or 3 slides?
I think we should first finish the 2 slides, then we will take up questions,
okay,
because we have been received of many more questions.
Okay, okay. We'll answer all of them in one go. Yeah.
Yes, sure.
So in case somebody is trading to portfolio manager, there is always a query whether it will be covered under the PIT regime. Absolutely yes. So whether this person or their immediate, that is the DP or their immediate relatives are trading to portfolio manager, please take care. As a compliance officer, please inform this to all your designated persons. They should take care to inform the portfolio manager not to trade in the securities of your company. Because in case they trade when your trading window is closed, the DP is held liable. In case they do a contra trade, the DP is held liable. In case they don't seek pre-clearance because the DP doesn't know the portfolio manager is trading, then also the designated person is held liable. So it's the responsibility of the designated person to inform the portfolio manager. There is a column, Schedule B in the agreement, wherein it will be clearly given, do not trade in these scripts. And mention this, your company's name will have to be mentioned there. In case, even after mentioning, the portfolio manager goes ahead and trades, then the DP is not responsible. He can show the copy of the agreement. It will be the portfolio manager who will be held responsible. Then, as long as the person is in employment, must comply, and in case he resigns or retires or his services are terminated, for 6 months after the disassociation also continues to be required to comply with the PIT regulations, like our trading plan. For 6 months cooling period, because it's assumed that for 6 months the person is in possession or he is having access to UPSI. So apart from that, there is a new requirement which is called as the institutional mechanism, which wherein the company is responsible to put in place an adequate, effective system where they will say that identify all employees who are having access to unpublished price-sensitive information as designated persons. They will identify what are all the UPSI that is floating in the organization. They will require that confidentiality is maintained for this information. They will also, that control should restrict on the communication and procurement of UPSI except on need-to-know basis. The mechanism should be in such a way that confidentiality agreements are entered into with persons whom we are sharing UPSI with. Have a leakage that is inquiry into leakage of information policy or suspected leakage of UPSI. Audit committee will have to review and there should be a policy, as I told you, and in case somebody suspects there is a leakage of UPSI or there is actual leakage of UPSI, and the policy should clearly lay down how the inquiry will be conducted, who will conduct the inquiry, how quickly the inquiry will be conducted, What should the report be like? Who should the report be submitted to? How will the board deliberate on the report? And whether the board will communicate it further to SEBI or not. That has to be definitely looked into. And there should be adequate whistleblower mechanism in the organization, robust whistleblower mechanism, which will encourage employees to actually, rake up in case they see that some information has leaked or they suspect that UPSI has been leaked. They will raise it up to the or chairman of audit committee or managing director or their own boss or anybody in the top management, and they shall not be victimized. The code of conduct should clearly include a clause that their whistleblowers will not be victimized. This also has to be included. So with that we come to the end. Now we take up questions.
Yeah, sure. I will start. We have received 5-6 queries. One by one, I will ask them. The first one is whether for de-placing of shares, approval of pre-clearance is needed to be taken if it exceeds the threshold limit fixed by the company.
For what? For deep?
For de-placing of shares.
De-pledging. Okay. See, when you are pledging the shares, it is an act that is done by the person voluntarily, for which pre-clearance is required. Now, when you revoke, revocation is also a voluntary act if you have repaid everything. Now, for that, there is no pre-clearance that is required because revocation will happen. Once you make the payment, the party with which the shares have been pledged will automatically invoke or revoke. In case we don't pay, it is invoked. If it is paid, it is revoked. But once it is revoked, we have to intimate to the compliance officer that the pledge has been revoked.
Suppose if a promoter of a listed company purchases shares of the company from the open market and within a span of period of 6 months, the company buy back its own shares. If such promoter participates in the buyback of shares, will it amount to contra trade?
See, contra trade, I already told you, participation in the rights issue, in a buyback, in a bonus, that is getting a bonus, or an exit offer and the delisting regulations, open offer and a takeover. All these are all exempted. So if he has, bought shares and then he's participating in buyback, which means he's selling, it is exempted. No problem at all. Can participate.
Just one more query that whether this derivative comes under the purview of this contra trade too?
Yes, because it's a security. So commodity derivatives or any other derivatives, financial derivatives, nifty derivatives, whatever be the derivatives. Derivatives is included under the term securities. So if we buy, now while we are on contra trade, somebody had asked a question very recently that the designated person buys the shares, but his wife sells the shares. Will it be treated as contra trade? It will be. Because they are both treated as one. Same way, if you buy in the regular cash market and sell in the derivatives market, contra trade.
Yes. This is one basically to this digital database. If the information is shared between two people in the finance department for the purpose of preparing this MIS or financial results, or the mere draft of result is exchanged within the finance department itself, then also whether there is a need to make a separate entry every time when the information is shared.
Absolutely, because we need to know who are all the people who are in possession of this UPSI. So this has to be shared. This has to be updated both within and outside. That was the mistake. When I did the audit this year, secretarial audit this year, many companies felt that it has to only have a base of the information shared with outsiders, which is not correct. It has to be with everybody.
One question is related to this media publication. Are the media publication agency also considered connected person through whom quarterly financial results, artwork are created and published?
That's a very interesting question. And somebody had asked this some time ago also in one of the seminars. And I would say it's a gray area. Let's say media person, what you are really, before you give your results to the media person, would you not release it to the stock exchange? Then only you release it to them, not to publish it in the newspaper. So at that stage, it's already published. It ceases to be a UPSI. But if you give them, like analysts I was giving you the example of Bloomberg for Manappuram Finance. They called this analyst and gave them the financial results. Although Manappuram said there is no leakage from our end, but the analyst somehow managed to get the financial results. But Bloomberg broadcast it to 2,000 people. So there was no problem because it was broadcast. In WhatsApp cases, what happened? Somehow somebody managed to get the financial results. Where from, how, we do not know. Whether it's from newspaper reporter or analyst or institutional investor, we do not know. But SEBI held that since it was shared with a closed group, it is UPS violation.
Fine. One more thing is about this structural digital database. Is it required to maintain the structural database of the consultants, secretarial auditors, statutory auditors, and also the persons who are doing any kind of audit specifically and their relatives, etc.?
Now, I think the question, if I understand right, they're asking whether I maintain a database of these people. I don't have a database of them. I have a database of the information I share with them. I am trying to make this very clear. The question is, do I maintain a database of them? We are not talking about database of people. We are talking about database of UPSI. Okay. So in case I share information with them, financial information with my statutory auditor. If I share anything for due diligence with my merchant banker, that goes into the data with the name of the person with whom I have.
One last question I will take. Though I think it has already been discussed, but still they want to know the consequences on this trading of shares. The promoters of the company inadvertently traded in the shares of the company. While the trading window was closed, what are the consequences of the same? Does the promoter make disclosure of the shares or traded to SEBI? The intention is obvious, I think.
Okay. Let me share some case laws with you. I have three case laws. One of Mr. Nagesh Valambe, one of Mr. Jangu Dalal, and one in Jagran Prasaran. Three different cases, three different people. But the conclusion is the same. Okay. Now let's take Jangu Dalal. Jangu Dalal is a director of the company. What did Mr. Jangu Dalal do? He traded when the trading window was closed. The moment the company secretary noticed it, he red flagged it to Mr. Jangu Dalal. Mr. Dalal immediately said sorry and said whatever be the fine or whatever, I will bear it. So the audit committee quickly got into the action and said that he had made a notional profit of X amount. Also 2 lakh something was collected from him and sent to the Prime Minister's Relief Fund. Then they also intimated SEBI. He also applied for settlement. Settlement application got rejected. It went for adjudication. And in adjudication, the method of calculation was different from what the company had calculated. And he was levied a penalty of around 7 lakhs or 8 lakhs or something. He went to SAT also. It was not accepted. Ultimately, he ended up paying that 8 lakhs because the method of calculation by SEBI was very different from the way the company calculated. This happened director of the company. Second, in the case of Mr. Nagesh Valimbe, he's a technical director of the company. He says he did not understand. He's very clear. I am a technocrat. I do not understand what is PIT. I don't know the spelling of insider trading. Nothing. I don't know the code. Nothing. He was holding some huge chunk of shares which was under lock-in. He wanted to sell these shares so that he could take the money and invest it into another venture of his. So he was just waiting for the lock-in period to be over. Did not know that there was a window closure. Sold the shares. So here, intention is, he says, I don't understand. I am ignorant of the law. But ignorance of the law is no excuse. So what SEBI did, when he sold 18 lakh shares. So they calculated what is the price at which he has sold. The next transaction, the difference between the two was about 2 rupees per share. So they multiplied by the number of shares he sold. 36 lakhs was the penalty he had to pay. So here ignorance was no. Third, in Jagran Prasaran, the company secretary himself, his wife, his sister-in-law, they traded without pre-clearance and when the window was closed for consideration of financial results. So here, who is involved? Company secretary is involved. Person who is supposed to, take care of the monitoring. Penalties were higher, but it was limited. So whatever be the consequence when you are trading, when the window is closed, whether it is by negligence, whether it's recklessness, by ignorance, quantity, only 10 shares, 50 shares, whatever, nothing is accepted, and it will be subject to a penalty.
So we have no more questions left. So I will now proceed towards a formal vote of thanks. But before proposing a formal vote of thanks, I would like to just give whatever explained today. It was a very beautiful session, I think. One of my best session on pit regulations. Some of the main areas I would just want to again recapture that one of case laws, this Mannapura Finance, how a small WhatsApp chat became a boomerang and led to insider trading. It was really nicely conceptualized and presented by you, ma'am. And then again, this informal guidance scheme on Kirloskar's promoter group, it actually put a onerous responsibility on compliance officer, because we all are company secretaries attending this session. They need to know there is a thin line between this insider trading information. They have a very hectic job to this following and compliance of model code of conduct. Again, Falcon Tires, again there is a code of conduct. It is a very beautifully explained by you. And this non-disclosure agreement, I think most of the company secretaries who are working in this area, they must have aware about this non-disclosure agreement. But how crucial it is sometimes for small things, they can the company lead to pay a hefty penalty for insider trading. So this was a total crux of today's deliberations. And before again, I would like to thank you for this beautiful session. It was you have beautifully given us critical elements and practical aspects of EIT regulations. As you rightly said, it is a criminal offense. That means it is not fall under the tort. That means civil wrong only. That will be not penalized for civil crime. That is a criminal crime also. And SEBI has putting a heavy penalties. Yes. They have increased the penalties also nowadays. And with this, madam, I would like to give thanks to you, to all the participants to attend this session. Many more sessions, I think we will hope that will be coming on this insider trading. And one more thing I would like to conclude. That learning is a continuous process. So we all are student every day. Though when we think we are a student every day, the learning become more interesting. And this Triple E series is something that the institute is taking a lot of initiative during this COVID lockdown. There are no physical programs allowed. So we are this as an institute level. They are doing this as a on the platform of webinar. And the Triple E's webinar series is also part of this. The main theme is enable, evaluate, and excel. To me, this platform is enabling us to evaluate, to introspect ourselves, what potential and capabilities we have to deliver and to excel our professional areas. So with this, I would like to thank you, ma'am. Thank you
so much. I enjoyed it so much, except some technical glitches here and there, but otherwise so wonderfully. Thank you.
Despite this technical glitches, it was a wonderful and learning session for all. And we hope the judgments, recent whatever. I think before ending this session, I would like to again, there is a movie called India Bull. This is based on this.
Yes, absolutely.
Yeah. And it shows that in the movie, it was shown that how this insider trading made that that Big Bull or Abhishek Bachchan a billionaire. So when you see that being a professional, that how insider trading are working. So
no, but one thing, movie showed him becoming a billionaire. But reality shows that billionaires are becoming paupers because of insider trading. Like Amlendu Mukherjee has been fined 3 crores 62 lakhs and he says he has no money. Their recovery proceedings have started against him. So movies might show people becoming billionaires, but reality shows that they are becoming paupers. So we should keep that in mind.
Yeah, sure. And I would like to request my IT team to display that Sahid ki Beti certificate. I'm sure you are aware of this.
Yes, it's a great initiative. Thank you so much.
So this is our Sahid ki Beti certificate as a token of honor, ma'am. That for this very.
It is also, devote this, as a sense of gratitude to our women's hockey team, which has done so well yesterday.
Sure. Yeah, they are doing wonders. They are doing wonders.
Yeah, so they have defeated the mighty Australians yesterday. So let me give this to them. This is their honor.
Kudos to Indian team too. And this Sahid Ki Beti certificate, this amount, we are not giving any mementos and planter to any of our guests or speakers. And this is a token noble initiative taken by ICSI, so that this fund will be deposited in the account of our martyrs who have sacrificed their life for our country. So is yeah. Thank you so much.
Thank you so much. Thank you. Yeah. Nice session. Thank you. Bye.